Thank you, Ms. Hall. You too. Good morning, Mr. Lewis. Afternoon. Raise your right hand. Swear or affirm under the penalties of perjury. Tell the truth, the whole truth, and nothing but the truth.
I promise you I will.
Okay. You are here today because the state of Indiana and your attorney have told me that you are going to plead guilty. Is that your desire?
Absolutely. Yes.
The state has filed a motion to amend the information for the purposes of a plea. Do you have any objection to that, defense?
No, Judge.
They are adding count 2, harassment, as a B misdemeanor. Court is granting that. I'm signing it, and we'll upload this. Here you go. Under count 2, harassment reads, on or about between January 8th, 2025 and January 11th, 2025, Michael Lewis, with the intent to harass, annoy, or alarm Caitlin Clark, but with no intent of legitimate communication, did use a form of electronic communication, to wit, X. Is that AKA?
Formerly known as.
Oh, formerly known as Twitter, to transmit an obscene message or indecent or profane words to Caitlin Clark. Do you understand that?
I'm sorry, Judge. The deputies are talking.
What are you doing?
He just spat something from his mouth into his pocket. We're just saying what it is.
You may not take any drugs, any...
It's a chew tool. It's just
A what?
He had headphones in his pocket that he was chewing on.
You cannot chew on headphones.
I'm nervous.
I understand that. But if you took any drugs, I have to delay this hearing. Did you put any pills in your mouth?
No.
All right. Did you hear the harassment charge?
And we've gone over it, Judge. We would even waive formal reading.
So you are pleading guilty to stalking, a level 6 felony, which is a lesser included of the level 5 felony, and added count 2, harassment, as a class B misdemeanor. Is that how you wish to resolve your case?
Yes.
By pleading guilty, you are waiving or giving up the following legal rights. Without the benefit of the plea, you were looking at 1 to 6 years in the Department of Corrections and 0 to 60 days on the harassment. I understand you want to talk to your lawyer, but you have got to listen to the court,
He's
please.
just nervous, Judge. He's just nervous.
Well, I can't have you talk to him when I'm talking to him.
We're
Do you want me to reset this?
No, we're ready.
All right. Do you want to plead guilty to the stalking as a lesser included and the harassment?
Yes.
All right. Under count 1, you could have received up to 6 years in the Department of Corrections. Instead, you will receive, under the level 6, it's up to 2.5 years. You will receive all of that, 2.5 years executed at the Department of Corrections. They may not take you to the Department of Corrections, and I understand that you don't want to go there, but that's what's in the plea, and that's what the court is ordering. I will recommend that you stay at the Marion County Jail.
Thank you, Judge.
Judge, can you note that over the state's
Over the state's objection. I don't think they, under the current policy, take anyone who does not have a level 5 or higher.
That's correct, Judge, but in the plea it's written Department of Corrections. Whatever agreement Marion County Sheriff's Office has with the Department of Corrections is their business.
Right.
The state would be asking for the Department of Corrections.
And the court will note that the plea agreement that you're agreeing to says Department of Corrections, but if they keep you here, the court's not going to do anything about it.
And we appreciate the court recommending the adult detention center.
I don't think I can recommend if it's in the plea.
I think statutorily it's the discretion of the court. But the reason
I can't. It says Department of Corrections.
Understood, Judge.
I mean, I've never seen them take a level 6 to the Department of Corrections unless they have a consecutive probation case that includes a major felony or level 5 or higher.
And it used to be by law that they would not. It is no longer by law that they will not. It is now, I think, discretion of the sentencing court.
But the agreement says Department of Corrections. All right. So, 2.5 years at DOC. On count 2, 180 days suspended. What are we doing with the
No probation, Judge. This is
no probation? They're running consecutively. And you're agreeing to have no contact with Caitlin Clark for the duration of the sentence. Do you understand that?
Yes.
You understand that you're agreeing to stay away from Gamebridge Fieldhouse, Hinkle Fieldhouse, Indiana Fever events, and any Pacer organization events.
Yes.
You're agreeing to remain in custody until sentencing. You will not receive alternate misdemeanor sentencing. All other aspects will be determined by the court. Is that how you wish to proceed?
Yes.
You're also agreeing that this, you're not going to appeal, and are you satisfied with the services of your attorney?
Yes.
He didn't set the competency. He didn't initial that. If you could have him initial this, that'd be
Oh,
great.
sorry. Do you have a copy? Do you want me to have a copy?
No, you can do my copy. All right, factual basis, please.
Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on or between December 16th, 2024 and January 11th, 2025, Michael Thomas Lewis did stalk another person, to wit, Caitlin Clark, by engaging in a knowing or an intentional course of conduct involving a repeated or continuing harassment of Caitlin Clark that would have caused a reasonable person to feel terrorized, frightened, intimidated, or threatened, and that actually caused Caitlin Clark to feel terrorized, frightened, intimidated, or threatened. More specifically, that between December 16th of 2024 and January 11th, 2025, Michael Lewis posted messages on X tagging Caitlin Clark over 800 times. Some messages contain lewd and obscene language. Michael Lewis then drove to Indianapolis, Indiana from Texas. His vehicle was captured on flock cameras driving past Gamebridge Fieldhouse multiple times. In January of 2025, Michael Lewis did purchase tickets for a Butler basketball game in which he knew Caitlin Clark would be in attendance. Caitlin Clark was placed in fear based on the number and contents of the post and the defendant's actions, resulting in her changing her scheduled appearances. As to count 2, harassment, between January 8th, 2025 and January 11th, 2025, Michael Thomas Lewis, with the intent to harass, annoy, or alarm Caitlin Clark with no intent of legitimate communication, did use a form of electronic communication, to wit, X, formerly known as Twitter, to transmit obscene messages or indecent or profane words to Caitlin Clark. And more specifically, that on January 8th of 2025, law enforcement officers contacted Lewis at his hotel and asked him not to post on X about Miss Clark and the things that he had been posting, and he continued to make vulgar posts tagging Caitlin Clark, all of which occurred in Marion County as contrary to the statute.
Is that what happened?
Sure.
It's not a sure, it's a yes or no.
Yes.
All right, court will find you guilty of count 1, stalking as a level 6 felony. Court will find you guilty of count 2, harassment as a B misdemeanor. Count 1 will be a lesser included of the level 5 to a level 6 felony. Parties waive PSI.
The state waives PSI, Judge.
We do as well, Judge.
Do you wish to proceed with sentencing today?
Yes, Judge.
Yes, Judge.
All right, you have a right of allocution. Do you wish to address the court prior to sentencing?
Yes, Judge. We would like to make a brief statement.
I see how many pages that is. Is it brief?
A couple pages, Judge. But Michael's,
Like 7 minutes, maybe.
I think it's going to be quicker than that, Judge. He's got some things he's want to say. He hasn't had a chance to talk until now.
This is his time. He may say anything that he wants. But do not say anything about not doing the crime, because that will undo your plea agreement.
We've gone over the agreement, Judge.
Okay, perfect.
Or, Judge,
His statement?
his statement. I know what he's going to say, Judge.
Okay. Go ahead.
I was originally told I had a month to prepare what I'm going to say at sentencing. Yesterday I was told I have 24 hours.
You can ask for a continuance of your sentencing if you
Just
want.
stating, I don't want a continuance. I'm just,
All right. I'm telling you that you have the right to have as long as you need to get ready for sentencing. But if you are ready now, then I'm happy to listen to you now.
I was originally told I had a month to prepare for what I'm going to say at sentencing. Yesterday I was told I had 24 hours. This sums up how this case has gone for me. I'm doing the best I can. What we had here is a failure to communicate.
Failure to communicate with whom?
Let me get there, Judge.
It was a master's class of miscommunication. Everyone involved, me, the website, Twitter, X, FBI, local authorities, Ms. Clark, Cambridge Fieldhouse, Hinkle Gym, field organization, the prosecution, defense, and then back to me. It was like the game telephone. And then the media gets involved, and now it's telephone on steroids. It's winter. It's 20 degrees. I'm sleeping in my car. Fatigue set in. I made poor decisions. For that, I'm very sorry to everyone who felt uncomfortable. Someone was interacting with my profile after every post I sent.
Okay,
Just-
this is, when you say somebody else, is you just admitted to me that you sent 800 messages on X.
Judge, he's not disputing the factual basis that he's made. He's explaining to the court why he let himself get to the place that he did.
He just said somebody else wrote the...
No. That's not what he's saying.
Okay, let me
He's
hear what
saying
he said.
He
Some-
made the posts,
All 800 of them.
all 800 of the posts. We're not disputing that. What he's explaining to the court is why he let himself continue posting, why I didn't stop after
Okay.
100, why I didn't stop
Okay.
after 200.
All right, I misunderstood. Finish the sentence so that you're not sounding like you're not admitting guilt.
After I sent the post, I
The
sent the post.
800 posts.
Yes.
Someone was interacting with my profile after every post I sent, just moments
Okay.
after I sent it. I thought it was her. That was a poor,
I think it's AI.
that was a poor, that was a poor decision because she never read the post. Thus, she was never uncomfortable with any of them. But it was just my imagination running away with me. I know almost nothing about Miss Clark's personal life. She attends basketball games. She plays basketball at Cambridge Fieldhouse. And she has a Twitter X account, which she does not manage. That's it. I don't know where she lives, what car she drives, cell phone numbers. I never followed her on foot. I never followed her in her car. I never hid out, hoping to take a picture. I never got an autograph. I've never seen her in public. I'm not the paparazzi. I'm not the FBI. I want her to be happy. I want her to be successful. I want her to be safe, which is generally how I feel about everyone in the world. But this isn't my notes, but I'm going to say it anyways. I'm under oath. I'm going to say it anyways. I would lay down in the Audubon to save her. Try me. I was never blocked. I was never muted. I was never reported to Twitter that my posts were inappropriate. My account was never frozen. Every post was approved by Twitter. However, everyone knows Twitter is not a serious website, and it's obvious many of my posts were not serious. I thought for sure I'd get blocked and I could move on, but it never happened. No matter how bizarre my posts were, I could never get blocked. Even after everyone knew about the post on January 9th, her social media team never blocked. They had 4 days, January 9th, January 10th, January 11th, January 12th, to block me. I wanted to go home. I would have stopped. It was cold. And I would not be here today if they had. The FBI was tracking me the entire time. When they tracked me to my hotel room, I was friendly, respectful, confident I had done nothing wrong. I finally asked them, how can I help you? Help me help you. They replied, well, just make sure you don't send any threatening posts. That's it. That's it. They confirmed I had done nothing wrong. Check the film. The film doesn't lie. But the FBI does. They arrested me 4 nights later. I've never threatened her. I've never even thought about threatening her. I've never even thought about thinking about threatening her. I will never threaten her. I'm not a threat to her or any other player in the NBA whatsoever. I will give an example of a threat.
No, we're not going to do that.
Okay, you just pled guilty to stalking.
Correct, Judge.
Would make
Specifically-
a reasonable person feel terrorized, threatened, frightened, intimidated. That's what he pled guilty to.
The charge that was dismissed was threats of sexual battery.
That's
Judge.
what I'm talking about.
That is what he has been upset about.
That's
basically
not
with
what he
him.
is saying. He is saying, I never threatened her. Now that I actually heard.
Michael, do you believe you're guilty of level 6 stalking?
Yes.
Do you believe that you made posts that would have made her uncomfortable?
Yes.
You're saying that you do not believe any of your posts threatened her physical safety,
Correct.
but you understand why some of these posts
Yes.
were.
Because they don't know me.
I mean, he may continue to talk, but he is going to talk himself right out of a plea if he continues down this road. I am not going to accept a plea of guilty for somebody who says they are not guilty. I'm sorry.
I think
That
he said
court
he's-
cannot. No, the first one, maybe. He was talking about other people, but he just said he never threatened her.
The prosecution charged
And she
me.
never read them, which is not true.
I think-
Part of what the plea says is that it actually caused her to feel terrorized, frightened, intimidated, threatened.
I think Michael would agree that you don't know how Caitlin feels, correct? You're not in her mind,
Correct.
right? So you are not disputing that your behavior made her uncomfortable.
Correct.
In fact, you understand that it did make
More
her
than
uncomfortable.
uncomfortable.
It made her afraid, it made her change her behavior.
Yes.
You understand?
Yes.
What you're trying to get across to the judge
Level
is that
5.
you do not believe you are a dangerous person, and you do not believe
That's
that you're
not what he's
wild.
saying. But go on. You may finish
That's
talking.
what he means.
All right. But that's not what the court heard. But go ahead.
No.
Go to the, I mean, do you understand when you are pleading guilty, you have to accept responsibility. That's part of the plea. You are getting a lesser crime, a lesser sentence, a lesser charge.
And Judge, I think when me and Michael have talked about this case, there has never been a doubt in our mind and our strategy that the state could prove a level 6 felony.
Okay.
Michael understands that
Then
100%.
he may finish his allocution. Go ahead.
In 55 years, I've never been violent towards a female. I protect them. I'm not a violent person. Just ask anyone in the jail. I'm kind and respectful to everyone.
I hope they do not have you and with female inmates that I can ask if you're feeling threatened, because in the jail, you are isolated, right?
No.
You have interaction with female inmates?
No.
Okay, all right, go ahead.
I really enjoy visiting Indiana. Notre Dame University, the town of Carmel, the downtown YMCA, and Cambridge Fieldhouse. They're all loaded with fun. Cambridge even had a skating rink next door, which excited me because I was looking for one. My birthday was in a week, and each year on my birthday, I go to the skating rink. Well, I think about the happy time my wife and daughter had the last time we worked together. We broke up several years ago, and I've been picking up the pieces ever since. I drove around the skating rink a few times, looking for a parking spot. The prosecution thought I was tracking Clark. It was a master's class in miscommunication, misinterpretation, and rushed judgment. One click on the block icon, I wouldn't be here today. If someone would have let me know she doesn't manage a website, I wouldn't be here today. Moving forward, I have a solution. I will no longer allow sports television, the internet, social media to be a distraction from what's really important to me. And this is what's really important. The world is headed for troubled times, big trouble. There's a war coming that will kill 1/3 of mankind. That will lead to an economic system of total control. You will be forced to make a purchase with your right hand or forehead, possibly a microchip or eye scan or something similar. If you opt in, it will cost you your soul forever. If you opt out, it will cost you everything you own, maybe even your life. My only hope, the world's only hope, is the Word of God, the book of Acts, chapter 2, the true church of Jesus Christ. This has power, real power, to heal a broken heart, a broken mind, and a broken soul. This is very important to me, and this will be my focus.
Thank you. All right, do you have any argument?
No, Judge, I would just like to make a record that the victim, Ms. Clark, is aware of this plea agreement and approves of it.
Thank you. Do you have any additional evidence or argument?
No, Judge, we'd ask the court to accept the plea and sentence him per the agreement.
All right, Mr. Lewis, I believe that you told me at your initial hearing that you had a prior for stalking somewhere else.
I didn't tell you that, but I do. That is correct.
Well, that's what the court remembers from your initial hearing. I do not believe that you are here because of a click of a button. I do believe that you needed to move on long before you sent 800 messages to Caitlin Clark. I do believe that your behavior constituted stalking. I do accept your responsibility, and I will enter judgment of conviction and sentence you according to the plea. I will recommend that you get some mental health treatment because you don't get it. If you think that you came here to go skating when they followed you around and told you not to go to the games, not to go to anywhere where Caitlin Clark was, and you continued to follow her and continued to send messages over and over and over, you are having zero contact with Caitlin Clark. You will, matter of fact, the court will recommend that you do not have any access to the internet while you're in the Department of Corrections or at the Adult Detention Center, because I think that you cannot help yourself until you get help. If they told you to stay away and told you not to go to Gamebridge Fieldhouse, you didn't listen. And they told you to stop sending messages, you didn't listen. No one sends 800 messages. And if you do not understand that people that are in a celebrity status have somebody make an automatic response every time you send, that is, and I think the court believes that that's AI, and it's not coming from her. She is not requesting that you have a friendship or that you have a relationship with her. She is doing her job, and she wants you to stay away from her. So the court will sentence you to count 1 to 2.5 years executed at the Department of Corrections if they keep you in the Marion County Jail, because that's where your medicine is, and you are, I do believe, taking it as prescribed. Hopefully not before you came to court today, like in court, but you said that was a headphone. And count 2, court will sentence you to 180 days suspended with no probation. Those cases will be consecutive. So it'll be a 3-year sentence with 2.5 years executed at the Department of Correction. What is this credit time?
We turned it into the court, I believe it's 197 days plus 197 days.
197 plus 197, if my math is correct. 394?
I believe so, Judge.
Yeah. Credit for 394 days. You will have a time. And then the court will recommend that you go back. Do you live in Texas?
Yes.
Court will recommend, I can't force you to go back, but if you don't have any family or friends here, you might want to go back to Texas, okay?
And Judge, I've been in communication with his family. I'll continue to be in communication with Michael through the duration of his sentence. I'll make sure we have a plan for his release.
Okay. And then the court will not issue any fines or court costs.
We appreciate that, Judge.
Do you want me to waive the PD fee?
I would request the court waive the PD fee.
Okay, court will waive that. So you are indigent to all fees, including the public defender fee. I hope you get the help that you need. I hope that if you are sending 800 messages to anyone that you have never met, that might be kind of an indication that they don't want to have any contact with you.
And Judge, I think everyone can see that he looks quite different than he did at his initial hearing.
For sure.
I think he was getting treatment while he was in Texas. He has medication-assisted therapy. He was living out of his car, so he didn't do good keeping on his medication. He is getting his medication while he's at the jail now. Our goal is to make sure that there's a plan so when he finishes his sentence...
And you don't want probation to follow?
No, Judge.
Okay. All right. You're going to have to get the medication on your own. Do you understand that when you're on it, you don't seem to get in trouble, and you seem to be doing well at the jail? And when people I'm just telling you what the court sees. When people feel better by taking the medication, they think they don't need it anymore. And so you need it.
I've been on the medicine for 20 years.
Oh,
I know I
perfect.
need it. I
All right.
take it. And, but, you know, the issue is that there's a sleep disorder. So as long as I get sleep and it's warm, and
Well, I wouldn't come here in the
then
winter.
I do a lot better. So,
They're warmer states.
yeah, I understand.
And I wish you the best.
Thank you.
And I tell everyone, good luck, and I hope not to see you back here.
All right.
But if you get a third one, this is a felony. They will file a habitual. You understand? That's
I understand.
okay. All right, good luck. Thank you.